name of my country, Brazil. So I always say that I'm a Brazilian twice. And I belong to the University of Itaúna in Brazil, South America, which is in the southwest part of Brazil. And I have a screen to share. Uh, uh, okay. Is it possible to allow me to share a screen?
Yeah, sure. Now you can
Oh,
share your screen.
okay. Thank you so much.
Sure, doctor, we can see.
Okay. I will put in the full mode, but if the screen doesn't move, you can interrupt me and tell me for the change. And as I said you before, I'm going here to talk about research methods and techniques. And I'm also from the St. Augustine Law College of Sete Lagoas, also in my state, Minas Gerais. Well, first of all, I will put in the full mode. Uh, I would like to talk about the nature of scientific research. And I put a text in order to help my speech, as English, it's not my mother language, it's my second language. And I think it's more easier for everybody to understand what I'm trying to give you all. Well, scientific research is a form of systematic inquiry aimed at the production of knowledge within an epistemologically coherent framework. And epistemology is the philosophical foundation of scientific inquiry. It defines what counts as knowledge, who produces it, and by what means it is justified. And continuing, we have Bachelard, 1934, that emphasizes that scientific reasoning involves a break with closeness, privileging method, critique, and conceptual innovation. This is the opposite of empiricism in its naive form. And talking about the historicity of science, we have that science, as argued by Thomas Kuhn, 1962, in the structure of scientific revolutions, is not cumulative in a linear sense. It is shaped by paradigm shifts in which the dominant scientific model is overthrown and replaced, not simply refined. And continuing, we can see or understand that this view challenges the idea of a neutral or objective progression and situates research within broader scientific communities, languages, and institutional power. Well, now in another step, I would
Sorry,
like.
doctor. Sorry, doctor, for interruptions. You can move your slide. Now here is, we can see the first slide. You can change the
Okay,
slide. Thank you.
okay, so I will try. Uh, I think this is perhaps the best way to show.
Now
Now,
that's okay.
yes. And I talked here. Yes. Okay. Now, okay. So let's continue. Thank you so much, Dr. Irfan.
Thank
Well, continuing, we have methodological paradigms. And it's important for the construction of knowledge of science. And the main author, it's Auguste Comte from 1830 in his Cours de philosophie positive. The positivism is based on the belief that science should concern itself with observable, measurable phenomena following the logic of the natural sciences. And the positivism has some assumptions. Well, which are these assumptions? Well, we have reality is objective and independent of the observer. We have scientific statements must be verifiable through experience, and the objective, the goal, is the prediction and control of phenomena. Well, the positivism, and as we say, Kant classified knowledge development in three stages: theological, metaphysical, and positive, with the later representing the maturity of human understanding through empirical methods. Later, the Vienna Circle, early 20th century, formalized this approach, establishing logical positivism with emphasis on formal logic and empirical verification. And for the better understanding for what I'm saying, I here give an example in law. And the example is evaluating recidivism rates after penal reform through quantitative indicators. That's a very good example of positivism. And another theory that we call critical theory, the main author is Max Horkheimer from 1937 with his book Traditionelle und kritische Theorie. Critical theory rejects the objective or objectivist separation of researcher and subject, and asserts that all knowledge is historically situated and ideologically mediated. And continuing the core principles. As core principles, we have knowledge is bound to power relations. Scientific inquiry must aim at social emancipation, and the subject-object relation in science is dialectical, not dualistic. And the next approach is still about critical theory. we can understand that this approach underpins emancipatory research programs such as feminist epistemologies, decolonial theory, and critical race theory. And the example is still in law because I belong to the area law. We have studying systemic racism in sentencing by analyzing in court decisions through the lens of power and structural violence. And continuing, now I would like to talk about the hypothetical deductive method. Particularly, this is the method that I most appreciate in my researches. It's the hypothetical deductive method. One of the most enduring legacies of classical science, the hypothetical deductive method, remains a central model for systematic inquiry in both empirical and normative research. And here it's important to highlight the structure and logic. And we have some observations. The first observation, identification of a phenomenon, a problem formulation, research question. As I always say for my students, when you want to research about something, the first you have to do is to have a problem formulation and the method. Which method you intend to apply? Because science is it problem and method. And of course, with the research, with the development of the research, we are going to achieve the results. Well, so continuing, as I said, the hypothesis, of course, it's the question, it's your tentative, and it's your wish for a testable proposition. It's very important. And we have also deduction. Deduction is a logical derivation of expected consequences that you wish to find. And the next phase, it's testing. You have to test through empirical evidence or legal reasoning. And for the area of law, that's what we use the most, legal reasoning. And here, it's the highlight of the research, it's the conclusion. The conclusion is a confirmation, refutation, or revision. And I always say to my students, when you come to conclusion, you have to return to your question, to hypothesis, and answer with confirmation or refutation. It's very important. You have to return in the conclusion and make your confirmation or refutation of your hypothesis. Continuing, still talking about the hypothetical deductive method, I like this author, Karl Popper, because for Karl Popper, a theory that is not refutable by any conceivable event is non-scientific. Popper argues that the hallmark of science is the falsifiability, not verifiability. Note well, it's very important. And a theory must expose itself to possible refutation. Continuing, now we are talking about adaptation in legal and social research. It's very important. And while the legal field, the law field, includes normative reasoning, the method remains applicable. It's important. And in doctrinal legal research, hypotheses can be formed about the coherence of legal principles. And when I do a research, and also with my students from master and doctorate in law, and my University of Itaúna, works with the protection of fundamental rights. And I always say that it's important to the research give a product for the legal community. So when you do a research, what product you intend to give to your community? And this product must be useful, practical, not only theoretical. It's very important to work and to give something for your community that you belong to. Well, continuing, still about legal and social research, while the legal field includes normative reasoning, the method remains applicable. In doctrinal legal research, hypotheses can be formed about the coherence of legal principles. And also in empirical legal studies, data can be used to verify claims about the impact of laws and institutions. It's very important to highlight. Well, now bringing an example, and of course, I bring an example in the Brazilian law environment. We have a hypothesis. The Brazilian General Data Protection Law, that we call LGPD, enhances transparency in public data processing. It's a hypothesis. And we have artificial intelligence, and it's a reality that we cannot deny the use of artificial intelligence. And in Brazil, we are also bringing artificial intelligence to the court laws, And in many situations, artificial intelligence has been using, because it's about Brazil. We have more 100 million processes in our courts. Brazil has a population of 200 million inhabitants, and we have the half more process uh, transmitting in the court laws, and our justice are not so fast as we would like. So artificial intelligence is being used, but the hypothesis using the hallmark of LGPD, if we can use, if you use artificial intelligence has to be transparent, has to be transparency, and the human revision is necessary because we have our federal constitution of the Republic of Brazil, and in our Article 5, we have 75 items about the protection of fundamental rights. And as I say, artificial intelligence cannot affect the fundamental rights that are written in our constitution. So that's our challenging. And here our hypothesis, LGPD enhances transparency in public data processing. Most of the cases, no. So human revision is necessary. So here we are testing, reviewing administrative cases, public audits, and stakeholder interviews. It's necessary. Continuing, and the conclusion, of course, about adaptation in legal and social research, we have a partial confirmation that mechanisms exist, but enforcement is inconsistent. And still talking about artificial intelligence, we have several draft bills transmitting in our national congress because we don't have any specific regulation about artificial intelligence. We are going to have, we have a draft bill, and just to understand, this draft bill intends to put more than 600 articles in our civil code. Our civil code, the Brazilian civil code, has 2,000 articles. And this draft bill about artificial intelligence wants to add more 600 articles. So professors, jurists, lawyers, judges have a lot to study and to understand. And this is the role of the university or universities discuss about it. And that's why, that's what we are talking here. Well, continuing, and now it's another method. It's about case study method. You know that the civil law, because the Brazilian law belongs to the civil law, not to the common law, because the families, the legal families, have differences. I know also we have another kind of legal family that has the foundation in religions like Sharia. It's very important to know, to understand. It's very important to understand all the legal families because we live in a globalized world that communication it's easy. We are here. I'm in South America. Most of the audience in Afghanistan, India, other beautiful countries, and we need to understand how the legal families works. And in Brazil, case study method is beginning to be applied because the tradition of civil law is to have the law, to study the law, and to apply the articles of the law differently from the common law that begins to study a legal situation from a case study. It's different. I'm changing my mind, my lens. I'm changing my lens to understand, to try to understand how the law works through other lens from common law, Muslim law, and other laws. It's very important, and I'm curious. I'm curious about everything, to learn everything. Well, continuing, because I'm very talkative, the case study method, uh, we have the main author, it's Robert K. Yin from 2018. In his book, Case Study Research and Applications. The case study method allows an in-depth, contextually grounded analysis of a bounded system. So this system, we have individual, group, event, legal decision, and institution. Continuing, we have some key features about case study method. This method investigates phenomena in natural settings, employs multiple resources, documents, interviews, observation, and its idea for how and why research questions. It's I always say the case study because you have to understand. So as I said before, you have a case, and from the case you apply the law. And as I said before, in civil law, it's different. We have the law that we apply to the case. It's another way. So here in Brazil, we are learning to the other way. I have written an article that I really believe that civil law and the common law, uh, they are getting approach, they are getting near from each other, especially in Brazil, because we import many legal institutes of the common law and we are applying in the Brazilian law, in the civil law. So we are importing so many legal institutions. The last importation is the precedents. The precedents, it's the common law. We never applied in Brazil the precedents. And now, since 2015, with our code of civil procedures, we are applying precedents in Brazil. So we have to go to the natural source which is the Anglo-Saxon countries, which applies the common law, to understand how they apply the precedents, because we don't know, we don't have the tradition. So that's why the method is very important to give confiable research. It's very important. Well, as I said, the key features uh, uh, even investigates phenomena in natural settings, employs multiple resources, as I said, documents, interviews, observation, and as I said, ideal for how and why research questions. Continuing, I bring here another example, still in the Brazilian context. An in-depth case study of Brazil's Supreme Court decision in the allegation of disregard for a fundamental precept that we generally call ADPF 442, and the case about abortion rights. It's another very delicate thing in Brazil. It's about the abortion rights. And our Supreme Court has pronounced about, because it's specific in our legislation. The judge, when have a situation that the law doesn't have a regulation, even if doesn't exist a regulation, the judge must give a decision, must give a decision. And of course, when you have a magistrate, a judge, we have some backgrounds as if he's conservative, if he's liberal, how he understands the law, of course. And our Supreme Court has 11 judges, 11 judges. So each one has a different way to see how the law works or how can be applied. Well, in this case, ADPF 442 about abortion rights, we have an epistemological position, and sometimes can be pragmatic or constructivist. And criticism limited by general, and it's countered by analytic generalization. Continuing, we still have another method that I would like to highlight here. It's the phenomenological method. And the objective of this method is to understand how individuals experience and give meaning to a phenomenon from their first person perspective. And here we have some key concepts: intentionality. Consciousness is always directed towards something. Continuing. Epoche is a suspension of judgments to focus purely on lived experience. And essence, identifying the core structure of an experience across individual variations. Well, Still talking about phenomenological method, we have some main procedures. The first one, in-depth interviews or personal narratives. Thematic analysis focusing on what is experienced, its textural, and how it is experienced, structural. Synthesis into a composite description of the phenomenon. Continuing, and the applications, because we have to have applications. We have many methods. I said one which I like most. It's hypothetical deductive method, but as we are in a course, I am obliged to talk about the other methods that we have to apply, and the decision which method to be applied, it's up to each one person, each one researcher. Well, so applications for this method, it's ideal for studying personal experiences of injustice, trauma, discrimination, or ethical conflict, especially in law and human rights research. So, as I said, it's very related to law, the area law. Continuing, and here I'm beginning my conclusions, I'm directing for the end of my speech. Hope that I'm not very boring or tiring for you all, but sometimes science, the theoretical explanations are very difficult, but we talk with pleasure, and I feel that I have a very prestigious audience, very interested about, and I'm very honored with it. Well, so for conclusions, research methods are essential tools for transforming questions into knowledge. It's important, very important to highlight here. Transform questions into knowledge. That's why we need knowledge and dialogue. It's important too. Ensuring that academic inquiry is not based on intuition or opinion, because sometimes students say, Professor, I want to research about a topic. All right, but what you intend to discuss? Oh, my opinion. No, it's not your opinion. You have to have a background of authors, courthouse decisions to build your idea, to build your knowledge. Because if it is opinion, it's journal, it's for television, not for academia, not for the universities. That's, I said, it's important because it's ensuring that academic inquiry is not based, as I said, on intuition or opinion, but on systematic, rigorous, and ethically grounded investigation. ethical investigation is very important. Yesterday, we had a prestigious professor from the Philippines talking about ethical in investigation. It's quite important, very important. And continuing, the methods, they provide the structure necessary to define problems, because we need problems to achieve knowledge, construct hypotheses, choose appropriate techniques, and interpret results in a coherent and valid way. That's knowledge. That's how we produce knowledge in a coherent and valid way. And my final words, in the fields of law and social science, mastering research methods empowers scholars to critically engage with complex realities, contribute to public policy, and promote social transformation through evidence-based analysis. That's very important. And here I would like to give my thanks, many thanks. And also, as I'm talking to a prestigious audience in Afghanistan, I have learned Tashakur. So, Tashakur you all for giving this time for me to talk with you all. Thank you so much. So I return to the coordinator, Dr. Irfan. It's up to you now. If the audience prefer, Dr. Irfan has my email. I can
Yep.
answer by email because I like this touching between different countries, and the questions will be welcome.
Thank you, Doctor, from your kind presentation. And there is no audience have a question. Thank you once again.